Welcome, everyone. We are so pleased to have you with us today for this webinar on learning how to protect your technology abroad. This is the last of our Business Learning Lab winter webinars on intellectual property with the USPTO. And they have been absolutely fantastic to work with. And I thank them very, very much for sharing all of this information with our audience. I am your moderator, Jenny Alton from the New York Small Business Development Center Central Office. Today's presenter is Harry Kim, Special Program Examiner with the International Patent Legal Administration of the USPTO. We also have his USPTO colleagues, Jeanette Parker and Ramon Mercado from the Eastern Regional Outreach Office, and they will be assisting with your questions in the chat today while Harry is presenting. Additionally, we have our own Mercedes Sanchez-Moore, our Director of International Trade, and Liam McMahon, who is our technology specialist here at the NYSBDC, to give you just a very brief introduction on how we help those types of businesses. This webinar is brought to you by the New York Small Business Development Center network of 20 campus-based centers and many more outreach offices which are located across New York State, along with a central office based in Albany. The NYSBDC is a U.S. Small Business Administration resource partner. Our free advising, education, research, and advocacy services are made possible by funding from the SBA, New York State, and our host campuses. So you know, we are recording today. We will share the recording with attendees in the next few days, along with a PDF copy of the slides through a follow-up email. Attendees are muted and will not be on camera today. If you have any questions during the presentation, please don't hesitate to type them in the Q&A box as they come up. You can open Zoom's Q&A box from that Q&A button at the bottom of your Zoom window. And we do also have chat if you need to message us about something. You will only be able to chat with myself and our panelists today, but we do recommend, so we make sure that we can get your questions answered, to drop those in that Q&A box. That'll help us keep things organized. And so with that, I am going to turn the time over to Dr. Mercedes Sanchez-Moore to share just a very brief message with you today. And Mercedes, I am going to bring up your slides right now.
Thank you, Jenny.
Okay, go ahead.
Hi, I'm Dr. Mercedes Sanchez-Moore, the Director of the New York SBDC International Trade Initiative. Next slide, please. The New York International Trade Initiative is a partnership with Global New York, USIAC, SBDC, SBA, EXIM, and other private and public institutions. We are part of the New York SBDC network, and we provide international trade and trade compliance. We specialize in export development and import operations. As an SBDC, we provide one-on-one to client counseling, innovative training, market research, and all of our services are free, customized, and 100% confidential. And here is my contact information. If you want to request a counseling session with me, we invite you to contact the closest SBDC center. You can also sign up to receive the SBDC newsletter to learn about our monthly webinars on international trade topics and realize your export potential today. I hope you enjoy this program on how to protect your technology abroad when you're exporting or importing. Thank you.
Liam.
I feel like I've done a lot of these. Hi, I'm Liam McMahon. I'm the technology advisor at the Binghamton Small Business Development Center, and I cover the entire state, providing support to various technology businesses. We can help with a host of different topics, including SBIR applications, some basic founder questions, financial projections, and even helping to identify sources of capital for your technology startup. We're always here to help. I would recommend reaching out to your advisor and saying that you'd like to have a conversation with me, and we can sit down and just see how our technology program can help you. Thanks, Jenny.
Thank you, Liam. Harry, we turn the rest of the time over to you.
Yay. Thank you, Jenny. Hello, everyone. Thanks for allowing me to be here today to talk about pursuing patent protections abroad, as well as the Patent Cooperation Treaty and the HEC system for industrial designs. Once again, my name is Harry Kim. I have been with the USPTO for past 30 plus years. I started first as a patent examiner. I examined patent applications directed to mechanical joints and connections, fences that you may see around your neighborhood, and mechanical projectiles such as bows and arrows. For past 22 years or so, I've been working as a special program examiner with the International Patent Legal Administration, where I get to educate and assist the patent community, develop policies, and resolve legal issues related to the PCT and other international projects or agreements such as the HEC system. So it's like we do a lot of that, and it's been so far very fun. And so looking forward to this session. All right, let's get started. Okay. First, let's start off by defining what a patent is. Okay, so basically, a patent is an exclusive property right granted for an invention. A patent owner has the right to exclude others from making, using, selling, offering for sale, or importing the claimed invention. However, the term of the patent rights is limited, and in that the right does not last indefinitely. For most countries, including the United States of America, the term is going to be 20 years from the filing of the patent application. Okay. Furthermore, the patent right is territorial, and that the protection is only good where the patent was granted. For example, if you have a U.S. patent, that gives you patent protection here in the United States, but that cannot be enforced anywhere else. Okay. So what is the reason for the patent? You get this property rights, but you got to give something back. So in exchange for getting the exclusive right, the inventor must disclose the invention. Now, this information will promote progress in that particular technology and hopefully make our world a better place to live. Okay, so it's a trade-off. So who actually grants patents? The granting of the patents is the job of the national patent offices, such as the United States Patent and Trademark Office and Japan Patent Office, and also the regional patent offices, such as the European Patent Office and Eurasian Patent Convention. Here's a listing of a regional patent offices around the world with their respective member countries. All right, so right now I'm going to be focusing on US patents. And for the US patents, basically there are three different types. We have the utility, we have the design, and also the plant. Now, in 2022, the USPTO received almost 650,000 patent applications, of which around 590,000 were directed to utility. We had 55,000 drawn to the designs, and also we had 900 plant applications. So by far, utility application gets the most use. The utility patent basically protects the utility or functional aspect of an invention. These patents are directed to process, machine, manufacturer, and composition of matter, or any new and useful information thereof. A good example would be a mobile phone that we all have, right? And all the technology packed into that little phone, okay? As far as the term is concerned, for utility patents, it's going to be 20 years from the filing date of the utility patent application. Okay, second, we have the design patents. For design, it only protects the ornamental aspect of the invention, such as its design or its particular shape. The invention here, once again, is not the way the the invention functions, but rather the way it looks, okay? A particular shape of the mobile phone that we talked about, or how the control buttons are configured on the phone, that may be covered by a design patent. Now, with the design patent, term's going to be 15 years from the grant date. And finally, we have the plant patent, which are directed to asexually reproduced plants, and that the plants can't come from seeds, right? So hybrids, mutants, and other modified plant varieties can have plant patents. For plant patents like the utility, the term is going to be 20 years from the filing date of the plant patent application. Here we have some samples of utility patents. On the left, we have Chamole device for string instrument, which was issued back in 1956 to Mr. Fender. And on the right, we have a printer patent that was issued in 1988. As I indicated earlier, design patent protects the way an article looks, including its shape, configuration, and/or surface ornamentations applied to the article. Here we see some samples of a mobile phone, watch, shoes, and guitar, which I'm pretty sure all of you can recognize. And finally, we have a sample plant patent that was issued in 2014. All right, now in trying to determine where to patent your invention, here are very few important things to consider. As I indicated earlier, patent rights are territorial in that patent protection is going to be limited within the country or region in which the patent was granted. Also, there is no such thing as a worldwide patent, which means you have to apply for and be granted a patent separately in each country or region where the protection is desired. Now, in this current worldwide economy, patent protection definitely can be a very important part of overall global business strategy. Now, let's look at some business considerations, right? Define your market in a country or region and determine how large it is. Now, if it is too small, the market is too small, then your product may not be commercially viable, right? You want to look at the manufacturing potential. What will it cost? Where can the product be made? And also learn about the economic trends, industry size, and future growth of a country or region. You want to be familiar with what your competition or your competitors are doing, okay? And finally, we need to look at the cost of filing and prosecuting the patent application. Okay, sometimes it could get very, very costly. Now, looking at the patent law considerations, standard of patentability and types of patent protection can differ in each country and region. For example, certain types of technology can be patented in the United States, but not in other countries, okay? And also the way prior art is considered in determining patentability, it can be different in each country. And also the breadth of protection is going to be different depending on the types of protection, such as a patent versus a utility model. Now, grace period is defined as time prior to filing a patent application, during which public disclosure by the inventor or applicant is not to be taken into account in determining patentability. Now, this grace period can differ between different jurisdictions. For example, in the United States, the grace period is going to be 12 months, but in other countries, it may be only 6 months or even no grace period at all, okay? The World Intellectual Property Organization, or what we call WIPO, they maintain a list of IP offices with their respective grace periods. You can see the URL there. So bottom line is this: avoid disclosing your invention publicly before filing your patent application in order to prevent your public disclosure from being used as a prior against you to prevent you from getting a patent. So that is a very important point. Now let's look at some enforcement considerations. Basically, the courts, they can enforce patent rights, but it does require action by the patent owner. It's important to develop an enforcement strategy for each country, since some countries have really very weak or even non-existent enforcement laws, while other countries may have acceptable laws, but the enforcement process may be slow or very ineffective. It's always a good idea to monitor the competitor to see if there are any infringement issues going on. And also, negotiating a licensing agreement may be very beneficial. All right, so we're going to go into the options for foreign filing. Basically, you have two options. All right, we have what we call a direct filing and also the PCT process. Direct filing deals with basically within 1 year from filing your application. Normally, you file it in a country party to the Paris Convention. With the PCT, it's something very similar in that you could file within 1 year from the first filing, but you go through this thing called the Patent Cooperation Treaty. For both of the situations, it's possible that you may need a foreign filing license from the USPTO before you file it in foreign countries. For PCTs, normally when you file with the USPTO as the receiving office that receives the application, foreign filing license is really not necessarily required to be filed for separate license, but rather filing of the application with the US office is also filing of the request for foreign filing. Okay, only time that you would need to get the foreign filing licenses if you filed a PCT in a country other than the United States. So Paris Convention is a United Nations treaty. Okay, so under the Paris Convention, what it does is basically if you file your application in your home country, you have basically 12-month time period to file in foreign country and still be able to claim benefit of the earlier filing date. So from the filing of your application, you got that 12-month window, and you can file in all of the countries party to the Paris Convention, and then you'll be able to get the filing date of the earlier date. Okay, it's important that subsequent application that you file in foreign application has to claim priority to that first filed application. So as far as the Paris Convention is concerned, there are currently 179 contracting states. So here's the timeline for filing directly, right? So once again, applicant files their application first here. As an example, maybe you want to file a provisional application here, right? Then within 1 year from that provisional application, if you want to get patent protection in foreign countries, you file the application in those countries, okay, and claim priority to that first filed provisional application. Now, when you file at that 12-month mark, each of the countries will have their own requirements. They want to see the application papers, let's just say an 8.5 by 11 size. Some of them will look for an A4 size, some of them legal size, whatever that they require, you would have to fulfill that requirement, right? And through each of office that you filed, there's going to be multiple prosecution of application. And at the time of filing, that within that 12-month when you file, you need to provide translations if necessary, and you need to pay basically all of the fees in order to get the application going. So you really don't have much time from the first filing to go and file in foreign countries under the direct filing. So why would you consider direct filing in foreign patent office? Well, sometimes it may be cost effective. If you're only looking to file in few countries, it may be cost effective to go through direct filing as opposed to the PCT that I'm going to be talking about. Okay. And also, if you know exactly where you're going to be filing in foreign countries, that's another reason why just go ahead and do it, because you know you want to get patent in a particular country. Okay. Also, you need to be prepared to pay the filing costs. Like I indicated before, when you file within that 12-month mark, when you do file it, you need to pay up, right? You need to pay the filing fees, translation costs, attorney's fees, you know, all of the fees associated with filing an application and prosecuting the application, you would have to pay it at that time. Okay. And finally, not every country has joined the PCT. So for those countries that have not joined the PCT, if you want to file in those countries, you cannot go through the PCT process. So you need to file it directly within that country. And Paris Convention gives them only 12-month window to do so. All right, so we're going to be talking about now the Patent Cooperation Treaty. So this particular treaty is a United Nations treaty as well. It was signed in 1970 in June, became operational only 8 years later in 1978. It is administered by the International Bureau of the World Intellectual Property Organization, or WIPO, and they are located in Geneva, Switzerland. So there is, like I said before, no such thing as an international patent, unfortunately, okay? So international application is filed under the Patent Cooperation Treaty, but it does not yield into an international patent. Basically, the PCT functions as a patent application filing system. And at the end of the day, this international application has to be prosecuted in each of the national regional office where you want your patent protection, okay? So I'll tell you a little bit later how that works out. So what are the purposes of the PCT? Well, ultimately to simplify the process of filing foreign patent application, also to give every regional or national patent office and the applicants the benefit of a search and an opinion on patentability by a major patent office, and option of further examination by a major patent office. So one of the things that will happen is, yes, the filing of the application is simple. That's cool. And with respect to the search and an opinion on patentability, there will be some work done. And this work is basically a patentability study. So that gives the applicant more information as to whether to pursue or not pursue their invention, okay? So here's the PCT filing timeline. So just like in the Paris route or direct route, you file your first application. As an example, once again, a provisional application. At 12-month mark, rather than filing in all of the different countries, you file the single international application that has the effect of being filed in all of the PCT contracting states as of that international filing date, okay? When the PCT is filed, there is only one set of formality requirement that's required, basically the PCT requirements. Now, some people say it's a little bit more stringent than the other offices, maybe, maybe not. But the benefit is you only need to meet one set of requirements under the PCT. And if that is done, basically you've met for all of the other countries as well. Okay, so at the 12-month mark, when the PCT is filed, basically starts the international phase. And then there will be certain work that's going to be done, like the search report, written opinion, publications, and what have you. But at the end of the day, you have that 30-month time limit, okay? Rather than filing everything at 12 months, you can extend it up to 30 months from the earliest priority date to make the decision to convert your international application into national application in each of the different countries where you want patent protection. Okay, so at the 30 months, when you want to nationalize in a particular country, that's when you need to provide the translations if it's required. You need to pay the fees and, attorneys and whatever. That gets to be held off until 30 months. So rather than the 12 months where you have to shell out a lot of money, you effectively get to, wait a little bit longer and have to pay it at that later point in time. So when we talk about a PCT contracting state, it's basically a country which has signed on to the treaty. Then back in 1978, we only had 18 contracting states, but currently we have 157. So it has pretty much grown a lot. Here's a listing of all of the PCT contracting states and their 2-letter codes. And here's a nice little map that shows all of the PCT states, contracting states in blue. As you can see, most everybody, at least all the big players, are definitely part of the PCT. Only one that's kind of, not still with the PCT is Argentina, but, that's going to be something that I think they will be joining sometime real soon. All right, some statistics here. In 2022, we had an estimated 278,000 plus international applications filed. It's been a just minimal increase from 2021, but the trend has usually been just pretty much upwards, okay? And of those, 59,000 plus were filed in the United States, so that accounts for 21%. For longest time, the U.S. led the pack on filing the PCT application, but within the last 2-3 years, China has actually taken over as the top filer of the PCT. Okay, so from inception in 1978 till now, the U.S. applicants are responsible for 28.9% of the PCT application. So we are by far the biggest user of the PCT. So what are the benefits for applicants? Well, once again, it simplifies the process of filing for an application because all they have to do is file this one international application that complies with one set of formality requirements, okay? And by doing that, it establishes a filing date in all PCT contracting state as of that international filing date. Postponing the cost that I explained earlier, rather than filing all of the fees and what have you at 12-month mark, you have actually up to 30 months from the earliest priority date to pay for the filing fees, translation fees, and fees that's going to be going to the attorneys and so forth. Okay, and also provides an earlier indication of prior art and written opinion as to the novelty, inventive step, and industry applicability. Basically, it's going to be a patentability study. Okay, it's not binding in that just because on the international search report and written opinion, these are the patentability study that's going to come out during the international phase, just because they indicate, oh, they're free of art in that they're quote unquote allowable, patentable, it doesn't mean it's automatically going to be patentable in the national offices, but at least it gives a good information, good, I guess, foundation as to where to start and what are the chances of getting a patent on this particular invention. Okay, and finally, gives extra time for assessing commercial viability in contracting state. Once again, because you don't have to get the application in at 12-month mark where you file in all the separate countries. You have up to 30. You get extra time to figure out, maybe do a market study and stuff like that. Okay. So what are the benefits for the offices? Well, because through the PCT process, there would be, like I said, international search report and written opinion of the International Searching Authority. Optionally, there's a supplementary international search report that could be possible, and also what we call an international preliminary report on patentability. All these reports are essentially patentability study. So if an application becomes into the national offices, those national offices will be able to see already some work products that's been done in that international application. So they don't have to start from ground zero, right? They already had some work done by a major patent office, and they could build up on that in helping them make the determination whether this should be patentable or not patentable. All right, so when we talk about an international application, it's a single application filed in one language, filed in one patent office. And that is the office, what we call the receiving office, that receives the patent international application, and usually the applicant's home patent office. So if a US applicant wants to file an international application, PCT international application, they file it in English language and they file it with the USPTO. Okay, as simple as that. Okay, and if it complies with the formal requirements, when I say formal requirements, we're talking about, like the paper size, the font size, things of that nature. It's going to be accepted by each of the national offices once the national stage begins. So once again, one formality requirement to meet, and if it meets within the international phase, then it's going to be acceptable in the national offices. And it's treated as a national application in each designated states as the international filing date. Basically, what that means is if the international application is filed today, it is as if it was filed in 157 countries with that single application. All right, so here's a blow up of the PCT system, very much like the one I showed you before, but we included in there stuff that may come out of the PCT. So month 0, you file the PCT at 12 months, then that starts the international search, and then there will be an international search report. Then publication will occur around 18 months from the earliest priority date. Applicant has the option of filing a request for supplementary international search report, which is very much like the international search report. And then they can either go straight into the national, wait until the national phase, which is 30 months, or they have further option of filing a request for international preliminary examination. They file a special form called the demand form to get another chance to see what the patentability of the claimed invention. Either way, whether you go into chapter 2, which is an optional stage, or not, the 30 months deadline will be the same for the two. Okay. Now, there are 2 phases of the PCT. We have the international phase, which is made up of chapter 1 and chapter 2. International phase is chapter 1 and chapter 2. Then we have the national stage. Okay. Chapter 1 is you're pretty much automatically in chapter 1 when you file the international application, and chapter 2 is optional. That's something that you don't need to go into, but some people choose to do so. And I'll explain why they may want to do it that way. So PCT chapter 1 basically deals with the filing and fees, filing and search. Okay. The international application, once again, is filed in the receiving office, and that's the office that receives the application. As far as the fees are concerned, there's going to be 3 set of fees, and that's going to be due within 1 month of filing of the international application. We have your transmittal fee, and that is for the processing of the international application by the receiving office. We have the search fee, and basically that is going to the searching authority that the applicant chooses for preparing the search report and written opinion. Then we have the international filing fee, and that fee will go to the International Bureau of WIPO, and that's going to be used to publish the international application and send copies to designated offices and some of the other stuff. So basically, they're the administrative body that deals with the PCT applications. All right, as far as the chapter 1 search is concerned, the international application is going to be searched by an international searching authority. International searching authority is a I guess label placed on some of these offices to do the international search. In order to be the international searching authority, there has to be certain criteria that has to be met. They need to have so many examiners, they have to have so much resources and so forth. So these are considered to be a major patent office. Of course, USPTO is one of the international searching authorities, okay? So anyway, the receiving office receives the application, applicant chooses a particular searching authority, and that searching authority will do the work. The work would consist of issuing the international search report, okay, which is form PCT ISA 210. And along with that, we have the written opinion of the International Searching Authority. So together, they will be issued, okay? Now, in addition to that, applicant may select to do another search report, what we call a supplementary international search, okay? And so they can make a request to have another search report done on what we call SISR, Supplementary International Search Report. All right, still in chapter 1, applicant can, after they get the search report, they have 2-month window to file amendment of the claims only under PCT Article 19, okay? And they would file the amendment directly with the International Bureau, okay? Then the international application will be published by the International Bureau at approximately about 18 months from the earliest priority date. Now, if there's a search report in the file or Article 19 amendments, they will be published as well. And all of the publication, the PCT International Application publication, is available on WIPO or International Bureau's website called the Patent Scope, and the URL is over there. So once the publication occurs, you'll be able to pull that publication out and also some of the items in that particular file. Here's a sample PCT publication, and this is a Japanese language international application, which was published by the International Bureau. You know, for most part, you know, it's hard to read, but they have special numbering associated with it. That's what we call the INID code, internationally agreed number on identification of BIB data. So we know INID code 21 shows the international application number and so forth. So regardless of the language, you'll be able to look at the number and figure out, oh, that's the international filing date, that's the international application number, and so forth. In addition to that, for the the English speakers, regardless of what the publication language is, the International Bureau will thankfully translate the title and the abstract into English. So that's always a good thing. So even if you may not know the contents really, you'll be able to get generally what the invention is directed to by reading the abstracts. So which is very convenient for us for sure. All right, so now into chapter 2, which is the international preliminary examination part. And this is an optional part of the international phase. So in order for you to be in chapter 2, applicant has to file a demand for chapter 2 examination directly with the International Preliminary Examining Authority. And this is under PCT Article 34. And typically why they do that is because they want to respond formally to the written opinion of the International Searching Authority. Like indicated earlier, written opinion of the International Searching Authority is basically detailed account of potential patentability of their claimed invention. Maybe the applicant saw something negative. Maybe the claims were not as good as it could have been. Maybe they want to fix something on the drawings. Maybe you want to fix something on the specification, whatever that may be. If they want to do any kind of amendments or they want to do a formal response or argument with respect to the patentability work, they would have to file the demand for chapter 2 examination. And they would usually file the response in the form of arguments or amendments of the description claims and their drawings. Okay, there's going to be some fee associated with it. We have the handling fee and also the examination fee. And then at the end of the day, the International Preliminary Examining Authority will issue the final report called the International Preliminary Report on Patentability Chapter 2, which is 409. In some circumstances, rare, rather than going out with the IPRP Chapter 2, which is the final report, prior to that, they may go out with another written opinion of the International Preliminary Examining Authority, Form 408, okay? But for most cases, the International Preliminary Examining Authority will issue just the final report, the IPRP Chapter 2. Then once that happens, basically the prosecution is pretty much done and over with. All right, so national phase requirements. So PCT Articles 22 and 39, there are certain requirements, namely for the national or regional entry, we need a copy of the international application, a translation of the international application if where appropriate, and the basic national fee. As far as a copy of the application is concerned, because the publication has already occurred, usually then the applicant does not need to give anybody the copy of the application, because we could rely on the publication by the International Bureau. Translation definitely needed, especially if that country does not accept any other language than particular language, then that application has to be translated in order for it to be prosecuted in that office. Okay. Now, national offices or regional offices may have additional requirements, and that will be listed on the PCT applicant's guide. Like, for example, in the United States, we need a copy of the application, translation, fees, also we need oath and declaration at a certain point in time. So that will be something that will be true for the United States, but they may not necessarily be true for other countries as well, okay? So why foreign file via the PCT? Well, if filing in more than a few countries, it may serve to be cost effective, okay? So that's one of the reasons. It provides additional time to figure out which application to be filed, right? Which countries to be filed in those countries, the application to be filed in those countries. Also assessing the commercial potential in the various foreign markets, okay? Like I indicated before, rather than filing at 12 months with a direct route, you have up to 30 months. So during that 30 months, additional, typically 18 more months, you could to figure out where you want to nationalize in and do some market studies and what have you to see the commercial potential, right? So that gets to be a big benefit to some of the applicants, okay? Deferring national patent fees and other costs, like I indicated before, rather than a 12-month mark, by going to 30-month mark, you're saving a lot of money because you don't have to dish out the money at that 12-month mark, right? You get to keep the money a little bit longer until when you have to nationalize the application. Now, if we're dealing with one or two applications, maybe it's not a big deal, but some companies, they file hundreds of applications. So holding on to the money to file in those 100 cases for another 18 months, right, until 30 months, that might be a big benefit for them, okay? And also provide assessment opportunity of the search report and written opinion result before incurring additional filing costs. Because the patentability study is there, the applicant will be able to, get good information as to potentially, is this going to be patented? It's going to be patentable or not patentable. If the international search report written opinion discovers exactly the same thing as what the applicant has invented, then it would not be very wise to try to get a patent on that particular invention, because obvious from the work products by the searching authority, it's already been done. So there's no way that this will be yielding into a patent at a later point in time. So that will be a good information for the applicants. Conversely, if the searching authority found nothing, right, and there's no art that has anything to do with maybe the claimed invention, then they could have confidence that, hey, this is something that would be able to get a patent on in the national offices. So it works both ways. All right, there are some strategies in filing the PCT. Now, everything has a benefit and, the downside as well. So here are the few common, filing options using the PCT. Applicant can file non-provisional here, okay, as the first filing, and then followed by the PCT within 1 year from that non-provisional, okay? Or a lot of times they would file the provisional application, and then within 1 year of that provisional, file the PCT application. Another way is you file the provisional application, and within that 1 year, you need to file the non-provisional for the US purposes, but in addition to that, you file the PCT, and basically the PCT is effective for filing in foreign countries. So you deal with both non-provisional and PCT together because you want a US patent, as soon as possible too. So you get the non-provisional going for the US patent, then PCT basically reserves your right to file in foreign countries, okay? And then final option is just file the PCT first. And that's all possible too. Once you file the PCT application, then you can nationalize in the United States, right, to get the US patent, as well as nationalizing in any other countries where you want patent protection, okay? All right, so as far as the information that's available, the Manual of Patent Examining Procedure, what we call MPEP, has chapter 1800, basically dealing with everything and anything about the PCT, right? Both the international phase and the national phase. We have Appendix T, which is the Patent Cooperation Treaty itself and the regulations under the PCT, and also Appendix AI for administrative instruction. On the USPTO's website, we do actually have a web page dedicated to PCT stuff, and that's basically my shop. So you have the URL there. There you could get forms, fees, rules, helpful hints, and whole 9 yards. Okay, and also we have the WIPO's website. So once again, WIPO is the the administrative body for the PCT. So they do have a PCT specific area as well. There you can find the PCT applicants guide, patent scope, newsletters, and so forth. Okay, so it's just plenty of information on the internet, thankfully. All right, now moving on to the HEG system for international design applications. So the HEG agreement concerning the International Deposit of Industrial Designs, also known as the HEG system, is an international system basically that allows industrial design to be protected in multiple countries or regions, right? Much like the PCT, right? Now, this system permits registering an industrial design in several countries by means of a single application filed in one language with one set of fees, right? Sounds like PCT. The HEG system is administered by the World Intellectual Property Organization, WIPO. Currently, there are 79 contracting parties, which comprises of 96 countries. The U.S. actually recently joined the HEG system in 2015. Now, by filing a single international application for a single international registration, applicant actually can register up to 100 industrial designs in any of the contracting parties. Now, all designs must belong to the same Locarno class and must designate at least one or more contracting party. And if the international registration is not refused by the designated contracting parties, then the international registration has the effect of a grant protection in that contracting party. The HEG system is primarily a procedural treaty, which means it does not determine the condition for protection or the right which result from the protection. Okay, each designated contracting party, they have their own set of laws concerning the scope of design protection. The HEG system is going to be only available to applicants having an attachment to a contracting party. So when we talk about an attachment, we're talking about they have to have either the nationality, domicile, or habitual residence, or real and effective industrial or commercial establishment. If there's more than one applicant, each applicant must have a connection to a contracting party. Okay, here are the basic requirements for filing a HEG application. The language has to be one of these three: English, French, or Spanish. The design application can be filed directly with WIPO or indirectly with the USPTO. Okay, there can be up to 100 different designs if they all belong to the same international classification. There's only a single set of formal requirements, okay? And a single set of international filing fees, which can be paid to WIPO in Swiss francs. Now, if filing the HEG application with the USPTO, we are referred to as the Office of Indirect Filing. Applicant has to have a US attachment. They pay the transmittal fee of $120, okay, which actually can be reduced by 60% or 80%, depending on whether the applicant is a small or micro entity. As to the international fees required by the WIPO, this can be paid directly to the WIPO or even through the USPTO. And if paying through the USPTO, the international fee has to be paid on or before the transmittal fee payment date. Now, once the HEG application is filed, the International Bureau of WIPO, basically they will perform formalities reviews for compliance with treaty requirements. They'll translate the application into 2 other languages. they'll record the international registration in the international register. They'll credit designation fees to the contracting parties. They'll transmit notifications received from contracting parties to the holders. And also they will publish the registration in the International Design Bulletin every Friday. And you see the URL there. And the designated contracting parties will perform normal substantive examination to the extent that it applies to the national filing, right? As far as the formality examination is concerned, it's not needed because it's already been done by the International Bureau. The designated contracting party may issue a statement of grant or protection. If there's any refusal, then it has to be communicated within 6 or 12 months from the date of publication of the international registration. For the US, it's going to be 12 months. And generally, a protection is going to be granted in the absence of any refusal. Depending on the contracting party, the start and duration of a grant of the protection will vary. For the US, the protection begins on the date of issuance of a US patent with possible provisional rights from the date of the WIPO publication. Now, duration is going to be 15 years from the issuance, which is a fixed term with no renewal. For European Union, protection is going to be will start beginning on the international registration date with maximum duration of 25 years. And for Republic of Korea, protection begins on the date of the statement of grant of protection with a max duration of 20 years. So we have on WIPO's website, HEG webpage, as you can see there. And on the USPTO's website, we also have HEG-specific web page, and the URL is there as well for you to use. All right, some helpful hints that we want to just share. So avoiding common mistakes. Okay, so here's a short list. Obviously, there are a lot of mistakes that can be made, but this is just a short list of common mistakes to avoid. Number one, keep it confidential. Do not make the invention public prior to filing a patent application. Okay, need to be aware of key dates and deadlines. Under the U.S., foreign, and international law. So you don't miss any important dates, right? Because there are certain filing date requirements. If you don't meet that date, then you may not be able to file the application. So it's very important that you know these dates and how much time you have, right? And also, if you're not familiar with the complexities of obtaining foreign patent rights, it is generally a very good idea to secure the services of a registered patent agent or patent attorney to avoid potentially losing patent rights. I know it is very expensive to use a patent attorney or patent agent, but if you don't process or prosecute these things right, then you may not be able to get a patent. And so even though it may be expensive in order to get a patent, if you don't know how to do it, you need to have somebody that can help you to do it, right? So it's pretty important, I would think. For more info on counsel or representation, you can check with the local industry contacts, the U.S. Embassy in each of the countries, inventors organization, and within the USPTO, you can check out the USPTO patent practitioner homepage. So you can see a lot of information on all of the people that are registered with the USPTO. We do not recommend any particular person or a firm, but all of the attorneys who are registered with the USPTO in good standings would be listed in that webpage. All right, resources. There are plenty of resources with the USPTO. Back in the day, I didn't think there were as many, but now definitely the USPTO have done really a good job of providing different resources. So that is, pretty much really helpful. And most importantly, it's free. So you can't beat free resources, right? As far as the PCT is concerned, we have the PCT Help Desk. Members of the International Patent Legal Administration, my shop, we actually, staff the PCT Help Desk. It's basically open Monday through Friday, anytime the USPTO is open, 8:30 to 5 p.m. with our phone number. There's an email address for general questions. So if you have a specific application that you want to call about, or you want to contact us about, you cannot use that email address, but you could call the number here, 571-272-4300. Okay. The people that work on the help desk, they're not clerical level. Most of us are, pretty experienced, seasoned veterans. So we'll be able to help you definitely if you have any PCT related questions, specific or general. International Patent Legal Administration website. Once again, that's my shop. On there, we have just this whole ton of information on PCT stuff, forms, fees, and just other helpful information there. And the Office of International Patent Cooperation website, OIPC, this office is actually our parent organization. And so they have lots of information there as well. Okay, this is a snapshot of the USPTO homepage. As you can see, it pretty much has everything. You could go into patent side, and when you click on the patent, it actually just opens up, and there's a lot of things that you'll be able to see there, okay? Through the USPTO's website, you could do the electronic filing, you could do the application inspection and management, you could search patent publications, the fees are there, other resources, and PCT and HEG filings are possible, right? And we have tons, once again, of information concerning all of that stuff. All right, so as far as the inventor resources are concerned, the Inventors Assistance Center, they provide general information about the patent examination policy and procedure. And the phone 1-800 phone number is there as well, and our website as well. The Inventor and Entrepreneur Resources is the USPTO's hub for resources and information for inventors, entrepreneurs, and small businesses. It has literally everything that you need as an inventor or entrepreneur. It talks about all of the different things that that's required for filing the application, and as to how to follow up and so forth. So that's really a good source as well. And then we have the USPTO Pro Se Assistance Program that provides outreach and education to applicants who file patent applications without the assistance of a registered patent attorney or agent. So that's what we call a pro se applicant. So pro se applicants are people that are not using the attorneys or agents. They're just prosecuting on their own. So we do have some information on how to best navigate through this whole patent process if you're a pro se applicant. We have also what we call a USPTO Pro Bono program, which is a nationwide program that matches financially under-resourced inventors and small businesses with a volunteer patent practitioners, and they will help file and prosecute your patent application. Okay, so you need to have a certain meet certain criteria financially, right? You cannot make above 3 times, I think, some level anyway. So if you qualify, then if you go into that, you're able to be accepted into pro bono program, and they'll help you file and prosecute the patent application. They will, however, not pay for like the filing fees, but as far as the work that's need to be done to file the application and also prosecute the application, they'll be able to do that. Okay. We have the stakeholder training on examination practice and procedure, what we call STEP. They provide information on the USPTO's examination practice and procedure. So you know, sometimes it's kind of good to know exactly how the examiners prosecute or examine these applications. So we do have these programs to kind of inform the public, you know, like the practitioners or even applicants. Oh, this is how we look at this application. This is how we'll process the application, prosecute the application. So you get to see what the examiner is learning and how they're able to process your application. Okay. All right, so Patent Center is a new tool which is available to all users for electronic filing and management of patent applications. So before the Patent Center, we used to have this thing called the EFS Web, public and private pair. Okay, so that was the, you know, our first electronic filing system. Then Patent Center came about, and you know, they were doing it concurrently, but now the EFS Web has been fully retired. So the Patent Center is the only thing that's available, okay, for, you know, electronic filing and management. And through the Patent Center, you can file the PCT application as well as a HAG application. And there's really something cool called the training mode option, right? So you can actually go into the training mode and you could go through the process of filing the application without really filing the application, right? So you could just play around and to see how the system works. And I've actually used that several times myself just to see how the Patent Center works, because we do get calls on, I'm in this page and I don't know what to do. Well, okay, so since I'm able to play with it, I'm able to help them, you know, help the callers in certain situations. So anyway, training mode is something that is, you know, pretty nice to have if you never used it before. This is the Patent Center homepage. Okay, so if you go into file the application, we have different things in there, like new submission, existing submission, and so forth. So you could just go through this process to file the application. You could do a Patent Center search, and then when you do the search, this is a page that shows the result of that particular search. And we have also Patent Public Search, which is a web-based tool for searching for patents and patent application publication. And this actually replaced the Pub East, Pub West, and other softwares that we used to have. Other resources, protecting intellectual property rights, stopfakes.gov, and that's really good. Good website. We have also the Office of U.S. Trade Representative, WIPO, Patent Scope. Patent Scope, once again, is where you're able to search the PCT publication, and then you will be able to see, you know, if anything's been published, you'll be able to get it out there. In addition to that, they have links to national offices, and if they particular national offices got a national stage of a particular PCT applications. In addition to that, they have just translation software called the Pearl, I believe. And that's really nifty and really nice. Okay. Also, the European Patent Office database, SPESNet, is there if you want to do, or if you need to do some searching on the European Patent Database, as well as the Japanese Patent Database. Okay. So these are just, you know, just some of the resources that are out there. Obviously, there could be a lot more, but you know, these are the most, I guess, well known at this point. All right, that concludes it. I thought I was going to take it a little longer. Typically, we take about 2 hours to do this class, but I know I rushed in some areas. So at this point, we could actually address any questions that you may have. I know my colleagues would have probably, you know, gave you the answers on the chat. If we were not able to, or they could not or did not already, we could just do it now as well. So if somebody could like read off the ones that hasn't been answered, I'll be able to address that.
Sure. And so Ramon and Jeanette, would you like to bring up the topics that have been in the Q&A box, since you know how to ask these questions better than I do?
Yeah, that's fine. I can do that. All right, Henry. So
Hello.
We have one question in particular, which I think it's a good summary here as well, and I would like you to address this in particular. So the question is, do I have, and if you can't hear me well, just let me know. Do I have to choose between filing a direct with a few countries or PCT, or can I do both? Say US, Vietnam, then do PCT. So he's talking about like doing a PCT and then do a bypass application, whether, yeah, that's it. Yeah.
Yeah. So yes, it's completely possible. All right. So let's just say, for instance, one of these options that I think I went through was, yeah, the filing strategies here, right? So after you first file the application, let's just say you want a patent application to be filed in Canada because you have a manufacturing plant there and you want the Canadian patent as soon as possible. Well, that's fine. Within that 1 year of the non-provision application you file here, you could actually file in Canada, right? And that will be the direct route, right? In addition to that, yeah, I may be interested in filing in these 20 other countries. Well, to reserve your right to do that, rather than filing in all those 20 countries for the direct route, you could effectively file the PCT application and use that PCT application to eventually file in those other countries, okay? For most people, once they file the first filed application, when they file the PCT application, it basically reserves the right to file in foreign countries, right? So what some people do alternatively is they file the PCT, and I said, and as far as the PCT is concerned, filing in the national stage is 30 months. 30 months is the expiration date, right? You have up to 30 months. So after you file the PCT at 12 months, in theory, day later, you could file in the national offices in any of those countries, right? Now, what benefit do you get? Really not much, right? One of the benefit is to hold on to the money for a little longer. You get the patentability study and all that stuff. But if you do it right after you file the PCT, you don't get any of those benefits, but it's still possible, right? For some people, I don't need those benefits. I need to file in, this particular country right away. And that's fine too. So in a way, yeah, the original questions, you could have both the direct and through the PCT, or you could have the PCT and then turn it right around and file a national stage of that particular PCT. And like I said, 30 months is, you don't have to wait that long. It's a deadline to file the national offices. So you could do it anytime after the international filing day. Long-winded answer to your question.
No, that's I think that's why I wanted you to address it, because you give that extra information and can highlight again what you have shown in the slides. All right, so here we have a question in chat. It is, what is the difference between an industrial design under, and I'm gonna butcher that, agreement versus a design/utility patent under PCT? So industrial design versus design utility patents under PCT.
So under the PCT, it's only utility. Okay, the PCT covers just the utility application, which is let me see here. Okay, so as far as the type of application is concerned, PCT is utility application only, right? There is no design PCT. When we say, people say the word design, in a very loose way, but design application is very specific in the patent world, right? So when you have a patent, right, you could say, oh, it's a utility patent, or it could be a design patent, right? But sometimes, like I said, people just use the word, oh, I designed something, or, and so they think, oh, it covers, no. So design, once again, ornamental, right? So Hague Agreement for industrial design is design, international aspect of design application, right? And PCT is the international aspect of the utility application. So that's why we have two separate treaties, right? For the Hague Agreement is for, design, as well as PCT, that's specifically for utility. Okay.
Excellent, thank you. I think that confusion stems from the fact that we at the US use design and then Europe use industrial, right?
Yeah,
Similar patents.
Yeah, definitely. There are certain terms that are kind of used like all over the place, and so yeah, it's just nature of the world at this point.
No, it's good information for those of you that are here, just to keep that in mind, okay, when you are looking to protect your IP abroad. So Harry, thank you so much. I don't have any questions here in the chat anymore, but please.
So I would say, while we have 3 experts on the line here, since we are specifically an organization that works with small business owners, do you have any recommendations for small business owners, particularly as opposed to, say, a corporation pursuing these types of patents? Do you have any recommendations that might be different for small business owners? You gave that great slide with avoiding common mistakes. And I just wanted to see, in your experience, have you seen any things to be particularly aware of for the small business owners?
Yeah, I mean, definitely one of the things that the small business owners have problems with is how deep their pockets are, right? The corporations, there's a reason why they're corporations, right? Because they have a lot of money, right? So for them, like, filing the applications and doing research to file the application or not, maybe they could just outsource it to somebody. They have a firm that handles all their stuff and they take care of it, right? Unfortunately, for small businesses, you don't have that. If you have extra money, that's going into R&D, not necessarily filing a patent. And that's the mindset I think a lot of the small businesses have. How, there's other things that are more pressing, more important, right, than patents and trademarks and what have you. So you got to prioritize, right? And they got to do what they got to do. But I think one of the things with respect to the patents and intellectual property is that there can be a lot of things that small businesses can do, and they could take, they could do the research and figure out a little bit, rather than having somebody else do the research, maybe they could do their own research. And it's just time consuming and it's not easy, but especially when you start off. But thankfully, the information is out there, right? And so when you do enough digging, maybe they'll be able to get a lot of good information out, okay? And that's just one of the things. And just being well informed, especially with respect to faith, right? I'm like, oh, this is great invention, but you know what? I don't have any money to pursue this, right? But it's already, I don't know, it's something that I need to make and sell and whatever. And then 3 years later, it's a big hit. And like, okay, now I'm going to try to get a patent. Well, unfortunately, you already missed the boat on that one, right? Because it's already out there. And so now they're going to have to think, oh my goodness, what am I going to do? Well, unfortunately, there's really nothing you can do. So there are consequences for, missing the boat, right? You're not going to be able to go there, right? So you just need to just be really careful and just be thoughtful and what do I want from this, right? And like I said, the PCT process, is not cheap. It's about $2,000 just to file the application, but it actually reserves your right to file in foreign countries, including the United States for that matter, until 30 months from the earliest priority date. So maybe that's something that, they may consider, right? Rather than filing directly in all those countries right away, maybe after you file the provisional application, file the PCT to kind of extend that out the time frame. And then, if they need to go through with it, then they go through with it. Otherwise, just you could let it die too. It's not a requirement that once you file the PCT that you have to nationalize it. You could just let it go, okay? But ultimately, it gives you, it reserves your rights until the 30 months from the earliest priority date. So that's very beneficial, I would think, for some applicants.
Thank you. Jeanette and
Yeah,
Ramon?
Yeah, I would like to add to that, and we do have a question here in the chat. I'll read it to you after we address this. First of all, I want to echo what Harry said. There are so many resources. Harry show you some of those. Remember that we have reduced fees for micro entities and small entities, so don't miss on those. Certainly the SBAs and SBDCs have so many resources for you guys as well. So to communicate with them, especially when it comes to getting money for startups, and getting funding as well. Now, I've had in this particular case that we're talking about a protection abroad, just because you are a small business, that doesn't mean that there are markets out there outside the United States that where you cannot go to. So many of small businesses produce your goods in abroad, right? You in China, Vietnam, et cetera, and that means that those producers, those countries where you're producing, are potential markets, and you have to decide early on when you're doing that business planning whether those markets are of importance to you, right? That's something that you have to decide, and if those are important to you, then start looking into protecting your intellectual property on those markets, because just like Harry said, getting early into those markets matter. Sadly, I have experience with some small businesses that they have had their intellectual property stolen, and when they try to go abroad into those markets, somebody else already saw the brand, or they already saw the product, and then they went ahead and patented or registered, etc. And when they try to register, they're no longer the first in that market. So just because you're a small business, think about the markets you want to address and reach, even now, even when you're just selling your wares in DC maybe, or New York only. Just because of that, don't limit yourself, don't limit your imagination. You guys are entrepreneurs, you're doing great work. I've seen amazing things coming out of small businesses, and just because you're small doesn't mean that you don't have a lot of reach. So I just wanted to highlight that as well. I'll let Jeanette add some thoughts to that.
So I'd like to echo Harry and Ramon's sentiments. The best thing that you can do is when you're a small business, you're lacking monetary resources. The best thing that you could do for yourself is educate yourself about the patent system for your inventions, or educate yourself about IP law for your business. We have a lot of free resources available at the USPTO. If you go to uspto.gov, there is a link called Access Our Free Services. And from there, you'll find a plethora of information to educate yourself. For example, if you'd like to file a patent, instead of just handing it to a professional, a patent attorney or a patent agent, it would be helpful for you to learn about the process so that you could be a contributor to the patent application process. And for example, if you want to protect your brand and if you'd like to file a trademark, we do have other resources regarding trademark as well. So the best thing that you can do is to educate yourself.
Thank you. And I just dropped that link into the chat. So if anybody wants to go check out those free resources right now, look in the chat and click on that. And one thing that I want to mention here is at the NYSBDC, one of our, I would guess, best kept secrets, but not a secret, is our research network. We have a fantastic research network here in New York, and that is not a common thing among SBDCs around the country. And so we have our own dedicated research librarians. We have a team of 4. And so if you need research to help you in making some of these decisions, things that you want to pursue, etc., our research network can be a fantastic free resource for you. So to be able to utilize the services of our research network, you just need to be working with your local center, and then they will hook you up to the resources that our research network has to offer. And we have one of our research specialists on the call today, and she just said Thank you. We are definitely available. So again, a free resource to get some of that research done that otherwise might cost you a considerable amount of money. So I just wanted to mention that. And then I'll turn the time back over to Ramon because I know we had another question. So go ahead.
Yes, there's another question in the chat. Is there a resource to check if a product I am importing is not infringing an existing US patent? Like if I was a wholesale importer looking to sell online?
You know, enforcement is something that the patent owners have to do, right? So it's difficult. You just have to, maybe do a research in like the patent scope or the USPTO's database to see if there is, a patent out there, right? And also, if you see a particular product, sometimes people put patent numbers on there, or sometimes they put things called like patent pending. Now, patent pending is a generic term that they could use, even if they filed a provisional application, which does not yield into a patent. But once they file any kind of provisional or non-provisional with the USPTO, they could use the word patent pending. Now, it's possible that it will become a patent, but there's also a possibility that it will not become a patent. If it doesn't become a patent, then obviously they don't get protection. So it's kind of, you could use it. But if it does get a patent, then if if you're importing something and it is actually, patented, was already patented, and the patent owner has rights to it, then they could they could be coming knocking at your door. So that's something that you just really don't know unless you just do a research. Yeah, I don't know of any particular way other than just, rolling up your sleeve and getting onto the database. And, all you have to do is, if you're doing guitars, you just, type guitars in the database and all of the guitars would come. And obviously, if you have a Mr. Fender's guitar that was, patented 60 years ago, right? You could copy that one, right? No problem, because yeah, the patent has already expired, so you could copy and do all that stuff, right? But if something that's, more recent, it's possible that they still have patent rights. Like I said, the patent rights expires basically 20 years from the filing of the application. So you could just, do the research that way to see if there's something that potentially has already been patented or not.
I would like to add to
yeah.
Oh, sorry, Harry.
Yeah, and also I'm not sure if it is necessarily wrong to contact the manufacturer of that particular device and say, hey, is this, was this patented? Is the patent owner does have exclusive rights to this or not? Because if it does, then they'll let you know, right? And so you would be, lot safer to just find out whether it's been patented. If not, then maybe it's okay to just import it and sell it over here. Not everything that we see in the marketplace are patented, right? I mean, people patent it because they want exclusivity, right? Exclusive right to it. But sometimes they just like, what, it doesn't matter. I have a better marketing center. And so I'll be able to sell it better than other people, faster than other people, until it's all saturated. Then I'm going to move on to the next product, right? So that could happen as well. Go ahead, Ramon.
Yeah, I like to say that this isn't a big issue with inventors these days, especially because the market moves so quickly with TikTok and other social medias. We have had inventors call us and talk to us about this very issue. And I will say, if the intellectual property or to that small business or to that inventor, very likely they highlight it on their own website. So take a look at the brand, do some search, like Harry said, not only on our patent system, but maybe on our trademark system, and just Google. You'll be surprised how many products have patents behind them, like small. I don't have it with me, but I have like a carabiner that I used to hang things on a backpack. And you go to the web page, and it actually says there are some European patents related to this one, just a carabiner. Also, if the applicant has registered their inventions through CBP, Custom Border Patrol, they will have a database that you can check as well, just to make sure. So there are ways to find out. It just takes work, like Harry said, going through those databases. But very likely, just look at the marks in there and directly contacting the manufacturer or the company that has the brand, the logo on it, will probably yield the quickest result. But hey, thank you for asking that. So many other retailers just sell the products and wait for that cease and desist. And so many inventors no longer, like you guys yourself, small businesses, don't have the money to hire an attorney. And we don't do any of that. Like Harry was saying, that USPTO doesn't help with enforcing. That's not what we do. So if you're going to do that, you will have to hire legal representation. It's more money, et cetera, et cetera. So thank you for having that foresight and thinking about searching and that issue. So
Yes. Jeanette, was there anything that you wanted to add on that topic? Let's see.
I think that my colleagues cover the answers.
All right. Well, we are about at time, so thank you. I know that this is a very specific topic with a lot of very specific things to learn about. And so I want to remind everyone that we are going to send you a link to the recording. You'll have these slides, so you'll be able to click on these various resources that have been shared and access all of this information. So thank you so much to Harry for presenting today. And thank you so much to Ramon and Jeanette for helping to answer questions. And thank you to our own Liam McMahon and Mercedes Sanchez Moore, who have been on the call today to let you know a little bit about how we help technology businesses and international businesses. And remember our research network. A lot of these questions that come up about research in any way, there are many different facets of research, and we have resources to help answer these questions. So please do make use of your tax dollars at work in the form of the NYSBDC so we can help you out. And I would ask also that if you have a few moments, we have an evaluation that will show up after, and we just love to get feedback on our webinars and to know what other topics you are looking for that would be helpful to you, so we can try to give you the information that you need. So with that, I'll just let everybody say goodbye, and any last words from anyone before we sign off for today?
Big thank you for letting us have the opportunity. I think this is awesome.
And I'm excited that we've created this resource that people will be able to watch in their own time, because I know sometimes making a webinar can be difficult with people's schedules. And so I'm really glad that we have this and be able to have it as a resource available for people as they maybe aren't all the way there yet, but then they start to get ready to export and to look at their intellectual property abroad. Mercedes, Liam, anything that you want to say before we sign off? Let's see, you're muted still, Mercedes there. Oh, we can't hear you still. I'm sorry, Mercedes, we're not able to hear you for some reason. Oh well.
Oh well.
The mysteries of Zoom, we never know for sure. So, all right. Well, thanks again, everyone, and bye-bye for today.
Thank you. Bye-bye.